said that they received it because they signed for it. Would those pass the test if you're not worried about the expense?
They would not pass the test. You have to do what the law says to do. The strict letter of the law is certified mail, return receipt. You have to do that. You don't want to give a trial court, Court of Appeals with Supreme Court justices an out. So you want to dot your I's and cross your T's, and then if you want to go above and beyond, have at it. Notice, notice, notice. You can't notice too much. But I would not want to go into court and say, but judge, we did this, this, and this, but no, we didn't send certified mail return receipt. The judge's going to look at you and go, why didn't you follow the statute? And then you're looking at the judge going, you know, that's a really good question. Why I didn't follow the law? I thought I'd go above and beyond the law and be smarter than what the Indiana legislators thought. No, I don't want that position. Any other questions? Okay, let's move on to this wonderful case that the Indiana Attorney General's office filed against asset recovery companies / bounty hunters / whatever you want to call them. If you're in that business, I don't want to disparage anyone, so I'll try to stay neutral. I'm not a big fan of it. A few years back, and time flies faster than I wanted to, but we changed the statute to cap what bounty hunters and asset recovery companies could receive, and that was 10% of the tax sale surplus. So again, we are a bid upstate. So the minimum bid on a piece of property is the delinquent tax amount plus the cost of sale. Very rarely on a nice or decent piece of property does it actually go for the minimum bid. Oftentimes, especially in the competitive counties, it gets bid up 10, 15 times of the value of the tax, or the amount of tax. So we have this tax sale surplus. So a surplus is created and sitting in the auditor's office, ready to be claimed by someone. Well, when people find out that there's money sitting there and it's sizable amounts, there becomes a huge fight over who gets it. And every angle has been tried. People buy judgments so they can be a lien holder and try to claim it that way. They buy assignment of mortgages. They go in and try to claim it that way. They'll go in and buy a quitclaim deed from the owner and say, I'm now the owner, I can go in and claim the surplus. I think I've seen as many ways to try to attack getting a surplus as you can imagine. But the Indiana legislature tried to fight this problem by saying, hey, if you come in after the sale, you're going to be capped at a 10% recovery on what you can receive from those proceeds. The money has to go to the owner, the mortgage company, a lien holder, and if you're an asset recovery company, you only can take fees of up to 10%. Before that, we've seen people have contracts of they get 60% of the money, 75% of the money. It's been pretty crazy. So on this particular case, there were 3 business defendants and 3 individual owners of those businesses named by the Indiana Attorney General's office in a lawsuit filed in Marion County. Judge Jones is here. Do you plan to talk about this case, or can you talk about this case? Yeah. No. It's pending in his court. So I'm guessing he's probably not going to talk about this case. So the Indiana AG's office filed this case. The parties are named in my materials. There were 48 original owners, and they were paid $13,640 to sign quitclaim deeds to properties that had $3.2 million in surplus. They were paid $13,000 in an effort to claim $3.2 million. The worst one was $450 was paid for a quitclaim to surplus that was $900,000. That's the most egregious of the situations. The AG's office filed a fairly nasty complaint that alleged violations of the Home Loan Practices Act by making misrepresentations, concealments, false terms in connection with a real estate transaction, by engaging in real estate transactions without proper license. It also alleged violations of the Deceptive Consumer Sales Act. I think the AG's office was throwing the kitchen sink at these people. It is pending in Marion Circuit Court. There have been a number of motions to dismiss filed. There was a hearing in May on a motion to dismiss at least 2 of the defendants, and the court requested proposed findings by June 10th. I don't know if has there been a ruling on that motion to dismiss yet? No. I expect a decision on that motion to dismiss will come soon. Another motion to dismiss for some of the other defendants is set for late fall. And again, what's really interesting is the Indiana legislative branch tried to combat this exact problem by changing the statute a few years ago and capping this at 10% so that this problem wouldn't be ongoing. They also make, there's a transfer of a tax sale property during the redemption period, I believe that there's a form that has to be signed in the auditor's office by the property owner